Everybody ready? All right, good afternoon. We'll call this meeting to order at 4:31 p.m. Following preliminary injunctions issued by 3 federal courts on Thursday, April 24th, 2025, the purpose of this meeting is to discuss the reinstatement of board policies that were amended and rescinded in response to federal directives. As we previously discussed at the April 15th, 2025 board meeting on February 14th, 2025, the U.S. Department of Education sent a Dear Colleague letter notifying schools of their interpretation of Title VI of the Civil Rights Act of 1964, and that any decisions or benefits based on race, color, or national origin would violate Title VI. On April 3rd, 2025, the U.S. Department of Education sent letters to states requiring that states' Department of Education and schools certify their compliance with anti-discrimination obligations in order to continue receiving federal financial assistance. Several lawsuits were filed by different organizations in federal courts around the country challenging the February 14th and its related enforcement. Since our last board meeting on April 15th, 3 court-issued orders on Thursday, April 24th, 2025, regarding the U.S. DOE's ability to enforce the Dear Colleague letter and the U.S. Department of Education's ability to enforce this letter, this certification requirement. We will start with the roll call for the record. I am the chair, Dr. Carmen Sultan, and I am present. When I call your name, please indicate if you are present. Vice Chair Hans Utz.
Present.
Is present on the phone. Board Member Anderson. Present. Board Member Herndon. Not present. Board Member Johnson Davis. Present. Thank you. The first item on the agenda is executive session. Do I have a motion to move into executive session for the purpose of discussing legal matters in light of the preliminary injunctions?
So moved.
Board Member Johnson Davis makes the motion. Is there a second?
Second.
Board Member Anderson seconds the motion. Is there any discussion? Hearing none. All those in favor?
Aye.
The
Aye.
motion, thank you. The motion carries unanimously. And we will move into executive session. And we will return. Thank you. All right, do I have a motion to move to exit executive session for the purpose of discussing legal matters in light of the preliminary injunctions where no votes were taken?
So moved.
Board Member Utz makes the motion. Is there a second?
Second.
Board Member Anderson seconds the motion. Is there any discussion? Hearing none. All those in favor?
Aye.
Any opposed? The motion carries unanimously. Thank you so much. As stated when the meeting was called to order and before we entered into executive session, the purpose of this meeting is to discuss the reinstatement of board policies that were amended and rescinded in response to federal directives. We also want to thank members of the school community for your feedback on this issue. At this time, we want to invite our legal counsel to provide an overview of the previous actions that were taken and the recent rulings by the federal courts that have resulted in this meeting.
Chair Sultan, Dr. Whitaker, members of the board. A great deal has changed since you voted literally 2 weeks ago tonight. At that time, you voted to rescind two policies, policy BAA, school board governance, policy BAC, equity. You then amended three policies, policy GAA, equal opportunity employment, policy IDFA, gender equity in sports, and policy JAA, equal education opportunities. At the time that you voted 2 weeks ago, you were on the threshold of the date had moved because you'd already been under a tight threshold that required you to have the emergency meeting before that because there was no room to move. The date got moved though. No one knew that was going to happen, but it did. And in order for Dr. Whitaker to be able to be assigned the certification that the city schools of Decatur was in compliance, certain changes had to be made. And in the process, as you know, certain policies needed to either be rescinded or rebuilt. Some of them were too complex to be rebuilt in a short time. We rescinded those two, amended the other three. What has happened since then is that there are actually 5 cases out there. 4 of them have injunctions or stays. One of them does not apply to the schools. It's only relevant because some of the same issues are being raised, but it affects civil businesses, if you will. But the principles are the same. The 3 that affect us, one is in New Hampshire. One is in the District of Columbia. One is in Maryland. The first case that doesn't affect us is also in Maryland, but a different court. And then the 4th case is in Massachusetts. Let me briefly discuss these cases. These cases are brought by different entities. The first case is led by the National Education Association. And their case makes challenges over the Dear Colleague letter that was forced upon everybody. And they make certain claims, and an injunction was entered in that case last Thursday. Second case is from the NAACP. It also is against the U.S. Department of Education, and it challenges the same letter, as well as the frequently asked questions and the certification process. It's broader. Last Thursday, an injunction was entered in that case. So we had a judge, federal judge in New Hampshire. We had a federal judge in the District of Columbia. They each entered that, an injunction. Third case with tantamount to an injunction, a temporary stay. We won't go through a law school class and discuss the slight difference between the two. The effect of each, for the purposes of what you're dealing with, are the same. It stops the Trump administration, stops the Department of Education of enforcing what they were trying to enforce. It also was entered on the 4th. All 3 courts the same day. They've done it maybe 2.5 weeks early. It might have helped everybody. Since were issued last Thursday in injunctions. Last Friday, 19 states have also filed a suit. Of those 19 states, one, state of Maryland, is below the Mason-Dixon line if you want to use the other line. All the rest of them are either in the West, Northwest, Middle America, and the Northeast. There may be other states joined, but at the moment, 19. They have concentrated their complaint on the certification process, and they have 4 primary claims there. Not quite sure whether that's the only thing they could agree to, or whether or not they think that's the torpedo that will hit the heart of the ship. Not quite sure. No orders have been issued in that case since it was filed last Friday. But Thursday and Friday produced big results. What are they challenging? They're challenging due process, both under the 5th and 14th Amendment of the United States Constitution. They're challenging on the basis of void for vagueness. When you read a law, you need to understand what the heck it's telling you to do. They use terms DEI. They use terms equity. they use terms like the practices of the school system, with no definition. And it's gonna be very, very difficult for them to change that and get them a definition that people would know what they mean. That's part of the problem we all have. What exactly is it we're trying to protect our system from? But, that's a primary claim. There are First Amendment claims: freedom of speech, freedom of association, viewpoint discrimination. Of the three courts who issued these injunctions in some states, two of them, the judges found that the acts of the Department of Education, this will warm your hearts, were arbitrary and capricious, basically. One didn't, but had a footnote that said that it smells of it, and they'll have an opportunity to prove it. Another claim is that the Department of Education cannot, by law, and that in effect is what they're trying to do. They are not allowed to do that on the federal level. And then there's the claim of lack of authority. The executive branch cannot do what they're doing. There are other claims in there about violating certain functions in the Constitution over who controls money and so forth. These claims are going to take some time to ferret out. And I suspect there's a good likelihood that the suit filed in Massachusetts last Friday could also end up with a stay, but that stay is not there at the moment. But there are three states. As it turns out, the country is broken into appellate divisions for the federal court. All three of those courts are in separate appellate divisions, which means if Trump administration, the Department of Education, seeks to try to get a higher court to overturn their injunctions or stays, they're going to rule on that. But the consistency of these orders, to get a stay or an injunction, there's several things you have to show. One of them is that there's an impending harm. And the judges spoke of that. That there's harm if we don't stop this till we know that it could really be done. And number two, another one, is that there's a likelihood from your claim that you will succeed. I mean, if the judge says, there's not a chance this is going to succeed, they're unlikely to give you an injunction. In each of these instances, those two things were found to be the case, which makes one be very encouraged that the plaintiffs in some of these cases will succeed. That means the landscape has changed because I mentioned the first case that doesn't apply to us. We have to have injunctions that apply to us. Those three are nationwide and apply to us. And so we are in a position now of where we were before you voted on April 15th. And therefore, you can go back to the extent you want to go back to where we were without being out of compliance, no question about it. So you have several decisions you can discuss today. What of what you did, if anything, do you want to rescind and go back to? And whether or not one of the other options is whether or not there would be a condition on what you do such that if these stays and injunctions were lifted or the federal government actually won its case, which would lift those things, whether or not you want to automatically put us back to where we are right now so we would never be out of compliance. Those are decisions that y'all will need to try to give some guidance. But I'll be happy to answer any questions because it is rather confusing.
Thank you.
Now, please understand, though, those stays could be lifted at any time. I don't think it will be. It could be overturned at any time. It's hard for me to imagine all three will be. And they could then try to all get to the Supreme Court. They could take those three, they could all end up in the Supreme Court. Then you get one decision that covers all of them. So, if there's any question, I'll be glad to try to answer.
Thank you. Board members, is there any discussion or questions for the legal team?
I think I have one, just to clarify, in terms of going back to where we were, before the Dear Colleague letter, effectively. Am I understanding that our two options then, if we were to do that, is we do that with the condition that we be in compliance in the event that one of these injunctions fails, or we just do it. I just want to make sure I understand the distinction between with and without compliance.
If you, let's just take any one of the policies, let's take the equity policy, just by itself. You said we want to reinstate the equity policy as it was before. That policy went through the standard process to be approved to begin with, you can do that. But you could, and if you did that and that alone, okay, but if the injunctions are lifted or the government wins its case, you would be out of compliance at that particular point. Then you would have to determine whether you want to get back in compliance. You'd have to come back and do some of what you did on the 15th again, if you wanted to be in compliance. If you wanted it to be automatic, you would put a condition on the motion to put equity in there, back in, but you would say in the event the injunctions, the stays are lifted, or the United States government wins and can do the things that it's trying to do, then you could have it where it would automatically flip us back to where we are now with that, such that you would never be out of compliance.
Just so that we're clear, all three injunctions would have to be lifted. The condition would be not a conjunction, or not a injunction,
But
but,
those three, yes, sir,
or any other future injunction.
correct, and I think there will be a fourth. I can't guarantee it, but it's hard for me to imagine. Those 19 states aren't going to ask for it. It's hard for me to imagine that the court's not going to grant that, given that three have already been granted. But yes, that is correct. It wouldn't, as long as one of them national that affects us, which is all three, two of them can fall, we're still protected. Yes, that is correct.
And then I wanted to clarify to just the community at large, as well as fellow board members, we are, I believe, talking about bringing back the two rescinded policies, the equity policy and the school board governance policy. And then we are talking about bringing equity in sports as originally written. The other two policies did not have any language related to equity in it. The adjustments there were position titles and things that don't actually exist within the system anymore, and so aren't really relevant for this conversation. In terms of what I think we heard from the community, it really is those direct policies related to equity and the equitable language in the gender equity in sports policy that we want to be talking about today.
The other two that you're referring to aren't really speaking of the equity issues. That is correct. And those amendments were more dealing with some titles that we thought could be problematic, or the system thought could be problematic if we weren't in compliance. And they could use that to say we weren't in compliance. So the three that have the meat, the three you just mentioned.
Yeah, I mentioned. Okay.
Yeah.
May I ask one other question? Compliance can mean anything from access to finances to allowance of structure, like, so if people are in, or if we are not in compliance.
Dr. Whitaker had to sign a document, just like 180 other superintendents in this state, to the State Department of Education, who was requiring it 2 days before Washington required them to certify that their districts were in compliance. And the compliance was if you will, a checklist of things, basically, but it is that we are, from their standpoint, we are race neutral. That's, when it really gets down to it, fundamental principle was race neutral in every way you can possibly imagine, and frankly, in your lawyer's opinion, to an extreme. I mean, it was just, but it nonetheless, that's what it did. And to be compliant, some of the things you can't have the language, to be compliant under what they had, you couldn't have the language DEI. You couldn't be talking about practices that wouldn't necessarily be maybe advantageous to one group as compared to another. You couldn't talk about equity and programs of equity All of those things were, so Dr. Whitaker, what you did and what the administration was able to do, met the deadline such that she could say we were compliant. When you put the equity policy back, if you put it back today, those are your decisions. You put the equity policy back today, according to that compliance, no, you aren't compliant, but it's okay not to be compliant right now because they cannot enforce it. So that's fine. You put everything back just the way it was, and you are not out of compliance because they can't enforce what they were demanding. So they've got to either win the case, well, they'd eventually have to win the case, but they either got to get them, their injunctions and stays lifted and then win the case. But once the injunction's lifted, that'd be the danger point, but the danger point continues to decrease with more states.
I have a two-part question. The first one is, can you clarify for us what this means with the intersection of some directives we've been handed down from the state? So, for example, the state had some thoughts about using language like bias training, and some of that language may be present in the equity policy. There are some policies that are passing through the state legislature about gender equity in sports. So if we bring these policies back in total, the way that they were before, and then there are directives from the state, what does that mean that we would have to be on a fast track to then subsequently amend them? Or how does the intersection of what we're being handed now from the federal government versus state directives, where do those two things align? And that also plays into things like language. So I think some of what we had been looking at was simply just the word equity, if we could bring that word back, and if that is going to be an issue with some directives that we've gotten from the state.
It could be. Obviously, we're still waiting on the governor to finish signing laws, but it could be. We will take those laws and see what affects the school system. Obviously, we've been following a lot of these as they go along, but we will then have to look at those, compare them to our policies and say, okay, we could be right back here, let's say in May possibly, over a policy saying, over a law that says we're going to have to do some things to this equity policy to bring us in compliance with state law. I mean, you don't sign a certification with those, you just are expected to comply with state laws. And every year, as all of you know, there are tweaks here and there to comply or add something in compliance with state laws. So yes, we could be back on any one of these that you put back in. But even with the changes we made, it's possible that the ones you just amended, it could be something in the law that you have to come back and deal with it again. Yes, it's an annual event. And this year, I think it might be a little more arduous than recent.
Well, so personally, I am not of the opinion that conditionality is necessary, given that we don't actually know what conditions are going to exist. I know that I do have a question regarding the certification that we made. When we made the certification, we were actually in compliance. So everything there is correct. If we reinstate the policies, because these injunctions exist, we are still in compliance. If those if those injunctions, are lifted and we are no longer in compliance, that does not change the fact that we were at the point of certification in compliance, and there is no mechanism to then follow up and decertify ourselves.
Well, the only thing is you have a superintendent who signed a document saying that we were compliant. And if we suddenly are not compliant, we'll just have to face whether or not we have to send a letter saying until our board can act again. And we may, this compliance is not presently fully accurate now. I don't know. We would have to protect.
But we would need to be given guidance around that. It's not currently extant in any existing policy or anything that we have from the state or the feds.
No, but
Okay.
that certification, as far as I can tell, will be hanging there the whole time this litigation goes on. So if they win the litigation, suddenly we've got a document saying we're in compliance when we know we aren't. I'm not worried about the board particularly, but it puts signature on that person who signed it, in an awkward position. So we would have to deal with that somehow.
Okay.
But, knowing this board, it would take whatever actions were necessary to resolve it.
And it's, because I'm on the same page as, board member Utz. You know, these policies were very important to us 3 weeks ago. We had them in place, and they were things that we upheld. They were our, you know, kind of our guardrails, and, you know, reminded us of what it is that we need to be doing for all of our students in CSD. And so I really would like to see the 2 policies that we rescinded. I would like to see those reinstated, and I would like to see the gender and sports equity policy reinstated, because we removed the word equitable from that, and I would like to see that replaced. Those other 2 policies, as he said, the changes weren't really significant.
The other two, no.
That it should be without condition, because we don't know what's gonna happen between now and then. And, you know,
Understood.
right, this was a priority for us before we received, the executive order and the Dear Colleague letter, and so I would like to reinstate with those policies without condition. And,
I think I've got a few questions, or I guess statements and then questions or a combination. So, you know, one, I hope the fact that we've moved as quickly as we have does speak to how important it is to honor our values and come here to do, I think, exactly what you're talking about. In the meantime, I am very nervous about the lack of condition for compliance, if that is going to put the day-to-day operations at risk. If I understand this correctly, in the event that these injunctions were lifted and, you know, without conditions, then we would be out of compliance. In the event that the injunctions are lifted, we are out of compliance, and then we rush to have a meeting to figure out how to manage this. Is that a crude summary?
That would be true, but I have to be honest with this body. In these changes where there are now two injunctions in one state, again, they achieved the same goal. And with a 4th case, 19 states involved. Ours not being one of them, of course. I think there'll be another injunction. That may not be the end of the suit, but I think there is a more likely chance today, knowing all this and having had a chance to look at it, than what we would have known Friday, to be perfectly honest, because those orders were just hitting Thursday night. And then we got the new suit on Friday. So in having the opportunity to look at them, I'm not going to say we would be in a fail-safe position, but I think we are in a pretty good position if you don't have conditions, that we would have the opportunity. We would do what we had to assist y'all to get you where you needed to be. But, you know, yes, we would not be in compliance as Washington describes it. I mean, the hard thing in this situation for y'all, the lawyers, just to say it, we have the most unpredictable administration in Washington than we've had in my entire lifetime. And so with that said, who knows what their reaction would be?
And I think that's where I'm going with this, is the honoring the values of our community, but also making sure that I am being as responsible as possible to the school district at the same time. So I think what I want to know, Hans and Jim, if you can answer, is why don't you want the conditions? Because that'll better help me meet the other aspects of it.
well, I voted against rescinding the policy in the first place. I thought that we have stated that we value equity. You know, we look at everything through an equity lens, and so I think it's important. I think what we have heard during public comment, what we have heard through the emails that we received, the letter writing campaign, is that the way and what the feedback that we received in the survey, and thanks to everyone that participated in the survey so quickly. While there was a strong, legitimate number of folks who do not want these policies reinstated, and we didn't have a summary because it was such a quick survey, but the little AI tool in there, when I said, how does the majority of the community feel about reinstating the policies? The little AI tool said that overwhelmingly, the community members, the stakeholders want the policy to be reinstated. Now, we did not put in there without condition, and with the without condition. But I just,
So I guess the question is, what benefit does it, if we bring the policies back, that's not the question on the table. Where does the with or without conditions bifurcation, where does that benefit us? So, I guess it sounds to me like if we put a without conditions on there, then if these injunctions are lifted, we're back where we started. If we put the with, then we're protected. What is the benefit to putting the without conditions?
The difference that I see pretty clearly is the reason why I supported taking the time and stepping back was because the perspective provided by our council was that we actually faced an existential, based on the requirements of certification, based on the way that they were requiring us to behave. With the injunctions in place and with the way this legal process is going to roll out, even if they lift, I do not believe that same risk faces us. Being out of compliance will not have the same sort of immediate, extant, grave risks to the future of the system the way that it did a week ago.
Then I pose the same question, what is the benefit of doing it that way?
Because I think it's a stronger statement in support of equity.
I totally agree.
But you're not, the issue is not whether or not you're going to bring the policies back. That's one separate part of the vote. The issue is the conditionality. You're doing it with or without the conditions. So I'm trying to understand what the benefit is, or it maybe, if I'm misunderstanding, I would love to be, I can be redirected.
The way that I interpreted the initial response from the community was that they didn't want us to and they wish they had an opportunity to tell us that. And so, and then the feedback that we got, you know, over the past 24 hours, because if they didn't want it to go away in the first place, then why would we make ourselves vulnerable? I've got the sense that this is the position that they want us to take.
I feel like the opposite is true. If you're saying we're going to take the policies back, and then if the injunction is lifted, we're still protected. That's the with condition, or do I have that backwards?
That's what I understood.
No, that's the with condition.
I got the sense that folks are willing to take the risk.
I am willing, I would say this, up to the dissolution of the school system, I'm willing to take the risk.
I think we do need to clarify something about the feedback, which, by the way, as always, I thank everyone for giving it. So I think most people know I teach, so I was looking at this probably at 2 o'clock. I want to say there were 152 responses. I think I started tallying them at about 120 something, and I loved all of the meaningful feedback. So I do think it's important, though, to recognize at least half of the ones I had tallied, I put in a pragmatic is the way I characterized it. I didn't know how else to. So I think, like Carmen, I know I'm here because I want to rescind or bring these back. That isn't up for question. I'm not as comfortable deciding that everyone has said without condition. And it does make me nervous to use yes, I think we all hate the fact that we are living in such an unpredictable time. It's awful. But I just need to understand why this risk that we're taking, what does that actually look like?
So the almost certain scenario that's gonna happen, right, if the injunctions get lifted, is that it still has to be adjudicated through the courts. And so even with the injunctions lifted, it is unlikely there is some differential level of risk that we immediately face. We would have the time to come back and talk as a body and assess the risks that we face at that point in time. And if at that point in time, the risks are basically nothing until we get a Supreme Court ruling, I don't want an automatic thing in our policy right now that still strips the equity policy away. I would rather at that point say, you know what, we actually aren't facing any real incremental risk. Let's not take the policies away, and let's see what the Supreme Court says.
That sounds like the with, though. How is it
No,
that?
that
how
is the
it,
without.
Well, how is it that having the with conditions is saying if those injunctions get lifted, the policies get taken away? Is that,
This is
Yeah,
what it
that-
says. That's what it says.
so it's saying that,
If it, either they get lifted or the United States government wins its case,
and
but that lifts them.
so then if the injunctions are lifted, if we have the with condition on there, then all the policies go away completely.
Yes.
That's what you're saying?
If you have the condition on there and the injunctions and stay go away,
Mhm.
what you have right now will come back into place.
Meaning we would lose the policy.
Right.
That's correct. You would be back right where you got to on the 15th with the vote.
And I think at that point, we would want the opportunity to evaluate whether we face a real risk. If we do face a real risk, then let's have a great conversation with the community. But if we do not face a real risk, I would want to leave them in place, not have something automatically strip them out.
So you're saying what you mean by the point that we would be where we were on the 15th, we would be out of compliance, where we would have to go back and rewrite all of the policies, or we would be protected by saying we had done all this work ahead of time, and therefore we were already in compliance? Which one is the with?
If you include the condition, if any one of those things happen, injunction and stay get lifted where we're unprotected, or they stay there and the United States government wins the case, including the condition would mean where you are now would automatically come back into place. You would be approving today that should those conditions occur, this is a conditional aspect of this would be a conditional aspect of motion, that what you're putting back in place would then flip right back where you are today.
No equity policy.
That's correct.
And I feel that we would want to have a conversation about what risk we actually face at that moment before we would want the policies to go away.
Now I'm conflicted because I'm not sure the community feedback, and please correct me if I'm wrong. I think, Jenny, you mentioned this. Did it allow for that compliance factor? I see why we're here to bring these policies back. That's not a question in my mind at all.
I mean, that wasn't that, just the policies were listed on the survey in the beginning. But I mean, the community is aware that we took a vote to be in compliance.
Mhm.
And what that resulted in was these two policies going away and equity being scrubbed from our website and that language being removed throughout documents. I would assume that the community is aware, those who are engaged, that if we bring those things back, we'd be out of compliance. So for the folks who said, and it was, it was close, but for the folks who said bring it back, I would assume, I haven't talked to them, that they're aware that that means we'd be out of compliance.
Because I feel like if we're going to agree to be out of compliance, then we need to be engaging with the community ASAP.
Well, we did.
Well,
I'm not saying we're agreeing to be out of compliance. I am saying that we are agreeing to come back and evaluate where we stand if the injunctions are lifted.
but am I correct to read that if we do this without any conditions, then we are at risk of being out of compliance
Yes.
if the federal government wins or those injunctions are lifted.
But we are currently at risk of being out of compliance with any change that might happen on any policy that we have anywhere within our entire policy book. And so we don't, in any other policy, try to pre-anticipate what might happen in some unknown future to try to maintain compliance.
I don't know if that's I mean, I understand what you're saying, but I think the difference here is there was a directive to do this, and the reason that we are able to come here right now as quickly is because there have been those 3 states, correct? And the 19 other that you described, only one. So, Hans, I do understand what you're saying in terms of any possible policy, but my understanding is we are talking specifically about a directive we were given, and we followed that, and then as soon as we found out on Friday that these other states and institutions have challenged it, and now we can do so, we've come here. I mean, is that correct? I just don't know the idea of saying that any policy could be up for grabs is relevant.
Can,
But we usually get forewarning when a bill will become law and those kind of things, just like we'll have to look at the laws that are coming into existence on July 1, to advise you on those laws. I must say, I think the risk, not for me to take sides. My job is to make sure you're aware of the risk as best we can assess them. And my job is to try to keep this school system from harm's way and try to make sure y'all see those potential harm's way. The degree of that potential harm is not as great today as it was Friday afternoon, because one, we've become enlightened about, not one, not two, but 3 different injunctions and stay. And we've become enlightened over the weekend by a suit filed in Massachusetts. The headline is New York is the lead plaintiff. There's 19 states. I don't know, there's no injunction now, but I would anticipate this high probability. So the risks have reduced. But I can never advise a client to just assume a risk. But then again, I'm not the elected official. Y'all get to make that decision.
So just, let me.
It's just whatever those risks are. The greatest risk, to me, has always been, we are not constitutional, we are statutory, only 21 of us. And if we were out of compliance, would that trigger somebody who holds a different view of Decatur than those of us who live here? So,
the summary comment that is everything I need to hear to be convinced is that we face less risk now, even if the injunctions are lifted. And so
we face less risk today than we did last Thursday, I can tell you that. Once those orders came in. Now, does that mean there's no risk? No, but it's less risk. 3 things have to happen right now, and I think it's gonna end up being 4. So, that's a judgment call that you make.
I'd like to make a motion.
I think the other thing, just as a final comment, I agree with you. I appreciate all of the community members who gave us feedback. We got lots of comments. It bears stating that the community feedback was very mixed. There were a lot of people who were very much telling us to bring these policies back as they were written, 100%, don't modify the language. A lot of people who felt like we shouldn't do this at all. A lot of people who felt like we should bring these policies back but modify them. So I think it bears just stating for the record that there are a lot of mixed opinions out there. I think it's perhaps worth it to realize that this is the first step to making sure that these policies are not only viable, but they have longevity, and that ultimately they can do the best thing for students, that Dr. Whitaker can put them into practice. But we did ask for community feedback. We did get it, and there were a lot of opinions, and they were not all the same for whatever it's worth. They were a lot of very different opinions. Just based on the discussion here, I don't want it to be thought that every opinion was in support of bringing these policies back, because they were not.
Make a motion.
Sure.
Okay. I move that we reinstate board policy BAB, school board governance, that we reinstate board policy BAC, equity, and that we reinstate board policy IDFA, gender equity in sports, as originally written, without condition.
Okay, we have a motion on the table. I think, there is a, there may be a way we need to modify the language a little bit. It's just for the conditionality. Is that okay?
Meaning if we don't mention anything about condition, it's just presumptively not conditioned?
Right.
Okay.
Is it
so
okay?
Is that all right?
Is it okay if I read it with the language for the conditionality?
Wait,
I don't know.
no, the motion that we're trying to do now, that I think
Okay.
that Dr. Johnson Davis brought forward is a without condition.
Okay, got it. Okay. We have a motion on the table to bring back, the rescinded policies, BAB, school board governance, BAC, equity, and then amended policy IDFA, gender equity in sports, by Board Member Johnson Davis. Do I have a second?
Second.
Board Member Utz seconds the motion. All those in favor?
Aye.
The motion passes unanimously. All right, so it sounds like we are going to take some action on those policies. Like we talked about before, we have option 1, which is without condition, and then option 2, which is with condition. So just for clarification, we have option 1, which is without condition, and then option 2, which is to reinstate the following policies with condition.
I ask a clarifying question?
Yes,
Didn't we just unanimously pass bringing them back without conditions, so there isn't any additional options?
okay, thank you for that clarification.
I do believe that was the sum total of our business today.
Okay, thank you.
Am I allowed to ask a follow-up question?
Yes.
Madam Chair, for clarification, so that the record will be clear, if I might. It is what I think you passed. Pass a motion, and I want to get these words correct, to rescind the actions
To reinstate.
that you took,
Oh,
that this board
Yeah.
took, that were adopted at your April 15th, 2025 regular board meeting, which rescinded board policies BAB, school board governance, and BAC, equity, and amended IDFA, gender equity in sports, and to reinstate said policies as they existed prior to April 15th regular board meeting. Is that your intention?
correct.
And if everybody agrees that was the intention, I just want to make sure that the recording secretary has
Mhm.
language that fits, because
Yeah,
I just want to be sure that it was to put those back in place as they were before April, as of April 15th.
so why don't we make that motion again for clarification? Do you want to read the motion, and then or why don't you read it, and then I'll make the motion, just so that it's correct?
Well, I think everybody disagrees that.
Yeah,
Okay.
I think that we did that.
But
All right.
what I think might have been slightly, I want to make sure that it was said policies as they existed prior to April 15th regular board meeting.
that's correct.
I understood that as well.
Does everybody
Y'all
agree with that?
You agree that was your motion?
Yes,
You agree that was your
That
motion?
was my vote, yes.
Y'all voted for that?
Yes.
correct.
Y'all voted.
Yes.
I just think it was important for the language to be
Yes.
clear.
Thank you.
You're quite welcome.
So I do want, though, to understand, so that the public also understands, what does our timeline look like now? Because, again, as we've acknowledged, we're living in unpredictable times. So, the good news is, I guess if there's any good news, that it sounds like it's going to be more difficult for the federal government to do what it had wanted. But in the event that that does happen, what are we committing to time-wise here?
Well, we just really would need just like 48 hours. Post the notice that we're gonna have another meeting, and then we would engage in a conversation about what, you know, whatever happens, what that means for us at that time, is my understanding.
Because I think I want, and maybe I have to do my own research, but I think I need a little more information in understanding that risk of being out of compliance. And we don't have to discuss it now, but I think it's something that we will have to.
Answer your question.
Yeah.
We will obviously be following the cases. It's unusual, it seems to me, that on these types of cases that have this kinship in these three different jurisdictions, that on the very same day, two injunctions in a day achieving the same point, although the issues are slightly different, should happen on the same day. I think it's far more unlikely that all three of those would be lifted at the same time. First of all, it's highly unlikely. You can go back to your trial judges, the U.S. district judges, and ask them to lift them and say, we have additional information why you shouldn't put the injunction in or whatever. But to succeed on all three seems highly unlikely. Their greatest chance is to go to their circuit courts of appeal. And that's three separate circuit courts. It's highly unlikely they would hear them and rule on the same day. But if we're watching them and we see, whoa, one falls, we'll let you know. Two falls, you're beginning to get closer to that trip switch. So we will keep our eye on them, and so will other warriors around, and we will let you know as things change, because if all of a sudden two of them have fallen and the other is being considered at another circuit court, if two fallen at two separate circuit courts, we may have a problem, and you may want to address it. What was the condition that was being considered? Let's say it gets down to there's only one stay holding up. This body could, if it chose, pass a motion at that time saying exactly what you didn't do today, you could do then when you're hanging by one stay. Blessing here is we're hanging by three. That's rather unusual. The cases will take a while, but you cannot predict the courts. They're easier to predict than the administration in Washington, but timing will vary on those cases because the issues are different when judges schedule them, when they move through the process. But they could all end up at the same time at the Supreme Court if decisions were out. So we'll see. But we'll keep you posted as we go along.
All right, thank you for attending the special called meeting. Our next Board of Education meeting will take place as scheduled on May 13th, 2025 at the Wilson Center. There being no further business, this meeting is adjourned at 5:58 p.m. Thank you so much.